Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. A few minutes early for you today. We'll start with Judge Elmore. He's sporting a fancy new camera angle this morning.
And when we were here on Friday, it was for a final pretrial conference. At that time, initially, there was not a resolution, and the case was going to continue to trial on our January 6th date, if I recall correctly. But afterwards, the defendant, January 6th, the defendant spoke with Mr. Harrison, and looks like they had reached a pretrial agreement. By the time that was notified to the court, the end of the court date. So go ahead, Mr. Barnes. Let's tell what's going on today.
Your Honor, it's my understanding that Mr. Beals will plead guilty to an added count of possession of child sexually abusive material as a first-time offender. And the people will dismiss the charged counts as well as the habitual sentence.
All right, so.
That is my understanding as well, Your Honor.
All right, thank you. All right, Mr. Beals, is that how you wish to resolve today's file?
Yes.
Please raise your right hand. You may remain seated.
Okay.
Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. All right, Mr. Beals, first of all, looking back on April 23rd of this year, were you on probation, parole, or bond?
I was on probation.
And has there been a probation violation allegation filed, Mr. Harrison?
I believe so, yes. I believe that's been resolved.
All right, it has been resolved? All right, thank you. Was that in this court or a different court?
Yes, Your Honor.
It was in this court.
All right, well, I apologize, I didn't recall doing it. All right, thank you.
It was a minute ago. It's not.
Yeah, it must have been. So, all right, thank you. So, Mr. Beals, I'm gonna go over here your charges, what the pretrial agreement is, what your rights are, consequences. Let's talk first about the charges. You are charged on a felony information with 8 counts. All 8 of those counts and a sentencing enhancement will be dismissed if you plead guilty to an added 9th count without the sentencing enhancement. Each one of these counts is a, well, not each of them. Counts 1, 3, 4, 5, 6, 7, and 8 are all charges of possession of child sexually abusive material. Now, initially, that is a felony punishable by up to 5 years and a mandatory minimum and maximum determined by the, well, that's a little confusing. Initially, it's up to 5 years. Hold on, I gotta get this right because it is worded differently for a second
It
offense.
is. And it's this.
It's right. Yeah, all right, so I apologize. Possession of child sexually abusive material, if it is a second offense, has a maximum punishment, and it's a felony, of up to 10 years and or up to $50,000, plus required registration as a sex offender underneath the Michigan Sex Offender Registration Act as a Tier 1. However, if you were previously convicted of a Tier 1, which in this instance it would assert that you have, it would then become a Tier 2. Or a Tier 2 a person is required to register biannually for a period for a period of 25 years. Now, there is a 5-year mandatory minimum as well. Plus, there's a habitual felony offender second enhancement that could increase that maximum penalty within the discretion of the court from up to 5 years to up to 15 years. However, all of those counts that I discussed will be dismissed. Count 2 is a charge of using a computer to commit a crime for which the maximum punishment is up to 10 years, but less than 20 years. Well, as I mentioned to you, the other 7 counts were all felonies punishable by up to 10 years. In this instance, for using a computer to commit such a crime, there is also a felony punishable by up to 10 years and or up to $10,000. Now that count will also be dismissed. These will be dismissed if you enter a plea of guilty to an added count 9. That plea would be to a possession of child sexually abusive material, but not with those enhancements. Give me just a moment. Mr. Carnes, did you pull down the packet code? I know it should be 750.145C, and I believe,
2. No,
one moment,
B is the second.
just a second here.
Sorry.
Well, there's several different choices based upon the number of images, but just a second here. It might be C4, a person who normally possesses, and it would be C4. Let's keep going down. Yeah, it's up to 4 years and or $10,000. Do you agree, Mr. Carnes?
Your Honor, I apparently can't sign into my laptop.
Well, I can tell you today, we're all slow because we cannot get into our emails, and we have a significant limitation on our computers today. So one moment, let's just take a look here at the numbers.
Looking it up on my phone, Your Honor.
Again, we're looking at 750.145C. I believe it's parenthetical 4.
I believe.
And it is a class F felony, punishable by up to 4 years and or up to $10,000, plus registration underneath the Sex Offender Registration Act. And if there was a prior sex offender registration offense, it goes from a 1 to a 2.
I agree.
25 years. Got
I
it?
agree with all of that.
Mr. Harrison, do you agree?
I concur, Your Honor.
All right, great. Mr. Beals, I want to make sure that you're following with us today. So right now, again, you've got 8 counts. 7 of them are possession of child sexually abusive material as a second offender, which includes a mandatory minimum of 5 years with a potential maximum of up to 10 years. However, as a 4th habitual offender, that could be increased to up to 15 years. Plus, there's the one other account of using a computer to commit a crime, and that is a felony punishable by up to 10 years. Plus, as a habitual offender, it could also be increased up to 15 years. All of that will be dismissed if you plead guilty to an added count 9. Added count 9 is what I would call a simple possession of child sexually abusive material without the enhancements, which makes a maximum punishment of up to 4 years up to $10,000, and registration underneath the sex offender registration of act up to, I'm sorry, for 25 years. Do you understand? All right. Now, if you enter a plea of guilty, you'll not have a trial of any kind, and you'll be given up certain rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you were to choose to testify. Mr. Beals, do you understand those rights?
Yes.
And even more importantly, do you understand that if you enter a plea of guilty and I accept that plea, you'll be forever waiving those rights as they apply to this particular case?
Yeah.
Additionally, any appeal as a conviction sentence pursuant to this pretrial agreement would be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me on the record today. So far, other than the terms of the agreement that I just went over with you a minute ago, have there been any other promises, threats, or inducements, or coercion, or force to get you to plead guilty that no one's told me about yet?
No.
Are you into the plea of your own free choice?
Yes.
Now, we're going to talk a little bit about potential sentencing here. I trust that Mr. Harrison has talked to you about the sentencing guidelines. Is that true?
Yeah.
I want to let you know that his speaking to you about the guidelines is an estimate. We don't know exactly what those guidelines will be. They'll be prepared by the Department of Corrections. We'll all take a look at them. But I also want to let you know that the guidelines are not mandatory. They are an important tool that courts are required to use. However, they are not mandatory. However, I'm sorry, also, has Mr. Harrison or anyone else asserted to you or tried to lead you to believe exactly what the sentence would be?
I saw that it was, the guidelines were 0 to 6.
All right, so that's an estimate. It means I don't know exactly what it is. I don't guarantee you what they're going to score. Let me just tell you, the attorneys do the best they can. And because you had that last case, Mr. Harrison should be able to go have gone back and look at your last scoring. And then it's really easy to figure out what it would be now. Key is no one's promising you what that scoring is yet. Whatever Mr. Harrison has told you, it's an estimated guess. Probably a lot better than what it would have been if there was a conviction on all accounts, obviously, because that had a mandatory minimum of 5. But you understand, whatever you've seen so far isn't a guarantee. I appreciate that. I know it's kind of difficult. Everybody wants to have a guarantee of what the sentence could be or the guidelines are. I don't do what are called Cobb's agreements where we guarantee a sentence at the time of the plea because I don't know how they're going to score. But anyways, knowing everything we've talked about today, Mr. Beals, do you still wish to enter the plea of guilty that we discussed earlier?
Yes.
All right, thank you. As to the added count 9s, I use the word simple just so we know that there's no enhancements, but possession of child sexually abusive material. How do you plead?
Guilty.
Now, before I can accept that plea of guilty, I'm going to have to ask you some questions. So what I'm going to do is I'm going to turn your attention back to that date of April 23rd, 2025. Were you living here in the city of Cadillac?
Yes.
And that's here in Wexford County, correct?
Yes.
And was there some kind of a check on your house or your computer, maybe by your probation officer?
Yeah, they did a random check.
All right, and so is it true that on or about that date, I'm assuming it was on a computer based upon all these charges that I saw earlier, did you possess on that computer some image of a prepubescent child?
That.
But let me do this, because Mr. Harrison has seen all the discovery. He's got a better idea of what it is. I'm just going to turn it over to Mr. Harrison and ask him to ask you questions. So it might be easier for him to speak.
Okay.
Go ahead, Mr.
Thank
Harrison.
you.
You also met with the state trooper that day, or a
Not
couple
that
days
day.
later?
Like 3 weeks later.
3 weeks later, okay. So the initial,
Okay, and was it of a male or a female?
Female,
And did it expose this person's, this child's body parts such as breast area, vaginal area, things like that? Okay. And one moment.
okay.
Excuse me. And this was on your computer, your device, correct?
yes.
Okay. It was a laptop, tablet, cell phone,
Laptop.
laptop? Okay, thank you. All right, Mr. Carr, should we defense provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements we have not talked about?
No, Your Honor.
One moment. I want to go back and ask, I'm sorry, do you believe the court's classes court rule 6.302?
Yes, Your Honor.
Mr. Beals, I got to go back and ask another question. Did this appear to be the images of a child who was prior to having reached the puberty age?
One was.
One of them was?
I don't know, maybe. I didn't really get a good look at it, but
You knew it was, you had seen it was on.
I knew one I'd seen, yes.
All right, thank you. Mr. Carnes, do you agree with all three with that added question?
Yes, Your Honor.
All right, Mr. Harrison,
I do concur as well.
thank you. All right, the court agrees, finds that this plea is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for the offense. Therefore, the defendant is found guilty of added count 9, which is a simple possession of child sexually abusive material. And that's underneath MCL 750.145C, parenthetical 4. And then it meets the definition of child sexually abusive material underneath paragraph 1, subparagraph O. Thank you. Mr. Beals, we'll be back here in court in about 4, maybe 6 weeks, depends on the holidays. The holidays always mess up everything. Well, we do sentencings in this courtroom on Monday mornings. Between now and then, an agent from the Department of Corrections is going to prepare a pre-sentence investigation report. You've had one of these before once. This report must be prepared anytime someone is convicted of a felony in a state court here in Michigan. It will describe the offense, the pretrial agreement, any statements, information you make or provide, as well as a score into the sentencing guidelines, information about your prior criminal history, information about prior performances on bond or probation. It will also include a score into the guidelines, which again, I told you earlier, are not mandatory. And it will also include a recommendation as to the sentence. Please keep in mind that it is merely a recommendation, as it is the court alone that exercises its discretion at the time of setting the sentence. There are 3 steps that involve you in the preparation of this report. When you leave this courtroom, you're going to go down to the probation office, which again, I know you know where it's at, and they're going to give you a packet. You're going to complete that packet, which you have done before, and you can update it with any other information that's changed. They'll also schedule an interview with you, and you have the right to have Mr. Harrison present at the time they conduct that interview. And the 3rd step is that Mr. Harrison, once he obtains this report, generally about 10 days to 2 weeks prior to sentencing, he's going to have to sit down, go over it with you to make sure there's any, determine if there's any need for correction or amendments or objections and things like that. All right, so again, when you leave the courtroom, you're going to go straight down to probation and parole office. Do you understand?
Yes.
All right, thank you. Mr. Carnes, any objection to the continuation of bond?
No, Your Honor.
Mr. Harrison, anything further on behalf of the defense today?
Nothing further, Your Honor. Thank you.
All right, Mr. Beals, you remain on your bond with the same conditions. So again, when you leave the courtroom, check in with your probation officer downstairs. Thank you. We are adjourned.
Hectic day here at the TCF bunker. Good morning. Happy Monday. Welcome to the Courtroom Files Live. Lots of distractions this morning. Halfway through that, we lost our ISP, so we switched to the backup. But we're still running, so that's good. Programming note, by the way, I will be exiting today at the end of hour 2. I have other business commitments that I need to tend to that will keep us from having a third hour today, but we will go until the end of hour 2. But that's why I started 15 minutes early, to try to offset that just a little bit. Let's switch it up. Let's go to Lake County, Ohio. We'll say good morning to Judge Vincent Collada, the Kool-Aid Man, as I'm calling him in my brain.
Your Honor, here this morning in the state of Ohio versus David Graves on 2 case numbers, the first being 24 CR 35 for a probation violation final hearing, the second being 25 CR 1342. On a prior day of court, the defendant did plead guilty to count 1, possession of cocaine, a felony of the 4th degree, and count 3, OVI, a misdemeanor of the 1st degree. Your Honor ordered a updated pre-sentence report on that case, which has been completed. We are here today for the purposes of sentencing.
He doesn't play to the PV, right? We need to do that first.
Correct, Your Honor. I think we just waived the probable cause. I don't think the
You're right.
final hearing's been officially waived.
We're going to address that first then. Case 24 CR 035, scheduled for a final hearing. Mr. Watts, what's the defendant's intention in that regard?
Thank you, Your Honor. May it please the court, after talking with my client, he is prepared to waive his final hearing and enter a plea of guilty to the violation, Your Honor.
Thank you. All right, Mr. Graves, in the first case, one that you've been on probation to the court for, you're charged with violating the conditions of your community control sanctions. Specifically, there's 3 alleged violations. The first is a Rule 1 violation, which requires you to obey all local, state, and federal laws, and it's alleged that on September 14th of this year, 2025, you were cited by the Whitfield Police Department for possession of a controlled substance, resisting arrest, open container, operating vehicle under the influence of alcohol or drugs, and failure to control. That's the other case that we have before us. You're ultimately pled guilty to the possession of cocaine charge and an OVI. It's also alleged you violated Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged that on that day, that other incident, September 14th, you were in possession of controlled substances, and you ultimately pled guilty to the charges for that. There's also a supplement or an addendum that was filed alleging another Rule 8 violation, again, which prohibits you from using any controlled substance, and it's alleged that a urine sample you submitted on September 16th after you were arrested tested positive for cocaine and marijuana. Now, you have the right to have a final hearing regarding these allegations, and that's a hearing where the state would be required to prove the merits of what they're alleging. Now, you could have this hearing, but you can also waive the hearing and plead guilty to the violation. Your lawyer has indicated he believes that's what you want to do, waive the final hearing and plead guilty. Is that correct?
Good morning. Yes, Your Honor.
Well, before I can accept your waiver of the hearing and your plea of guilty, I need to make sure you understand the potential consequences you face if you are found, in fact, to have violated the conditions of your community control sanctions. If, in fact, that did occur, the court could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it could be 6 to 12 months in prison, and that could also be ordered to be served consecutive to any potential prison sentence that may get imposed for the new case, the other case that we are here for on sentencing. You understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive that hearing and plead guilty to the violations?
Plead guilty, Your Honor.
Very well, then, as to the allegation that you violated Rule That you violated Rule 1 by having been convicted of a new criminal offenses. What is your plea to that?
Guilty, Your Honor.
As the Rule 8 violation for being in possession of controlled substance, what is your plea to that?
Guilty, Your Honor.
And as to the Rule 8 violation set forth in the addendum for testing positive for marijuana and cocaine, what is your plea to that?
Guilty, Your Honor.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions in case 24 CR 035. We will now proceed to sentencing in that case as well as the sentencing in 25 CR 1342. We'll do both together. Any reason not to do that, Mr. Watson, or any reason not to proceed to sentencing in either of these cases?
No, Your Honor.
Then is there anything you'd like to say on behalf of your client in regards to both of these cases? Make your comments and obviously go for both cases.
Thank you, Your Honor. May it please the court. Yeah, I'm going to be brief. I know we had discussions in chambers. Mr. Graves, I believe, is a good person who's got a very serious problem. I know he's denied this problem to not only this court, to probation in the past. I think in discussions in chambers when probation brought up that it finally caught up to him, I actually thought that was very appropriate. I think it did. And unfortunately, how it caught up to him on this new case, the facts are obviously not good at all. He was behind the wheel of a vehicle, passed out. The vehicle was still in drive, on the road. And it took officers. They had to get into the car, put it in park. Took them a while to wake him up. Obviously, the cocaine was found as well. Your Honor, Mr. Graves has told me that he struggled with this for quite a long time. He knows this court previously gave him really 2 chances. They gave him a chance, and then I believe there was a probation violation on the old case already, and continued him on probation. So. And he was doing well there, I believe, for a while. Unfortunately, he fell off the wagon and hard. And Your Honor, we're here hat in hand. I know the court can do a lot today, has a lot of discretion with regards to sentencing. I'm going to respectfully ask the court to consider a minimum sentence on both cases. Mr. Graves has expressed to me that he knows he's got some time ahead of him, but he plans on utilizing that time wisely. He wants to enter into some programs, do some AA. He wants to get out sober, and he wants to be sober. He doesn't want to be in this position ever again. He's expressed to me he's getting older. He's tired of this. He's tired of living his life like this, and I'm going to respectfully ask the court to take into account that he has accepted full responsibility here. He's very remorseful, and I'm hoping he'll get the help that he needs. Thank you, Your Honor.
Thank you. Mr. Graves, you have the right to address this court before you're sentenced in both of these cases. Is there anything you'd like to say in either or both cases at this time?
Yes, Your Honorable Judge Collado, please accept this letter as I have written for mercy in regardless to my crime I have committed, in which I am truly apologize and must first explain that I am reason to believe this is the root because of my actions and behaviors as a child growing up without a father figure were hard. Just to say that I'm sorry, and I do have a problem, and I'm sorry that I came in front of you and everything. And I have my own business and everything. I'm trying to just ask for the minimum on my fines, minimum on my license and driving privileges. And I apologize, and I have a problem, and I want to use this time, like you said, that you give me and everything to help better myself. And got 8 kids, 7 grandkids, and all like that, and everything, Your Honor. And just asking for plea for the mercy on the courts, Your Honor. I got a long letter. I ain't gonna take up.
Sorry?
I said I have a long letter. I ain't gonna try to read, take up a lot of time.
Well, you can say whatever you'd like to say. I'm not limiting you at all. It's up to you.
It's just above. And like I said, both my parents, they died of overdoses, and Mama was a prostitute. I was grown at 14, and I just made the wrong choices in life and all, and that's all. That's all, Your Honor. Just thank you for the mercy of the courts.
Thank you. Mr. Watson, anything else?
Nothing further, Your Honor.
Contra for the state of Ohio.
Thank you, Your Honor. The state is recommending prison on both of these cases. By my review of the pre-sentence report, the defendant has 8 prior misdemeanor cases, 7 prior felony cases. He was on probation at the time that he committed this new offense. The facts of that new offense are very serious. There is nothing that I see that would recommend him that he is amenable to community control sanctions, so we would ask for prison on both cases. Thank you.
Thank you. This court has reviewed the pre-sentence report investigation that was done in both cases, the original PSR done in the 24 case, as well as the updated PSR that was just completed. There's also a drug and alcohol evaluation that was completed in this newer case. I've read and considered that. I've considered the facts and circumstances of both cases, the nature of the cases involved. I've considered everything that's been said here today. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2929 11 of the revised code. As for the factors in 292912, in the older case, the 24 CR 035 case, I'm going to incorporate all the findings I made at the original sentencing hearing, first PV, with the additional finding at this time that the defendant has, again, failed to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. In fact, one of the findings, one of the violations was for actually committing a new crime, so recidivism actually occurred. In regards to the 25 CR case, the court notes in regards to the seriousness factors, just the very nature of the offense itself makes this much more serious than normal. One of the, quite frankly, it's only an F5 possession, I get it, but it's one of the worst ones I've seen. You're stopped at a red light, cars and drive, with your foot on the brake for a long time. There's one woman that pulled up behind you, sat through a whole cycle, then she left to go pick up somebody, came back and you were still there. People were beeping their horn, knocking on windows, reaching in your car, and you had no idea. And you're driving a car in that condition. Putting everybody in the community and everybody in that area at risk. You want to harm yourself by using drugs or drinking, whatever, but when you put the other people at risk, that makes it much more serious, and that's what happened here. And the officer in this case opened the door, put the vehicle in park, removed the key, you didn't wake up. Yelled at you, began tapping you on the shoulder, shining his flashlight in your face, you didn't wake up. Shaking you back and forth, yelling at you, you didn't wake up. And you're driving a car in this condition with people, other citizens around. Nothing makes it less serious. As for recidivism factors, in the new case, the court finds the defendant was on community control sanctions to this court at the time that he committed this offense. He has failed to comply with previously imposed sanctions ordered by the courts, including this court. In fact, he was on probation in this court. He had violated just in July. And despite his history, despite the fact that I gave him a break when I first put him on probation, I continued him again with the first PV. And within, a month after getting out of jail, maybe 2, he did this. He's got a significant criminal history. He's been to prison 4 times before already. He's not responded favorably again to previously imposed sanctions. A drug abuse problem that relates to the offense, and he's adamantly denied he has a problem. Even though he's got a history of drug problems, tested positive for drugs, has drugs on him, he pointed, you're entitled to minimum sentence and mercy. You've been to prison 4 times. You're on probation when you did this. Why do you deserve mercy? Why do you deserve a minimum sentence? You don't. You're 49 years old, and you've been doing this your whole life. Wherefore, is sentenced to this court in case 24 CR 035. Defendant served a term in prison of 9 months. He's given credit for 181 days he's already served. Case 25 CR 1342 is the sentence of the court. Defendant served a term in prison on count 1 of 15 months. That will be served consecutive to the prison term imposed in 24 CR 035. Since it's consecutive, there's no credit on that case because he's getting all the credit on the first case. 181 days includes credit for both cases. Count 3, there's a sentence of 180 days. It's concurrent to the sentence in count 1. Impose the minimum fine of $565 on count 3 in the new case. Both cases, I'm going to suspend the defendant's driver's license for 3 years. That's a concurrent suspension, though. 3 years in each case, but concurrent. The court's going to order defendant to pay all costs incurred in both cases. Need to advise you upon your release from prison. You could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, this is for both cases, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed by this court. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. That's for both cases as well. 25 CR 1342, order the forfeiture of the contraband and instrumentalities as part of the specification in count 1. I'll dismiss the balance of that indictment as well. Lastly, the court finds that consecutive service is necessary to protect the public from future crime and to punish the offender. This consecutive sentences are not disproportionate to the seriousness of his conduct and to the danger he poses to the public. And the court finds that he committed the offense in the 25 CR 1342 case while he was on community control sanctions to this court in 24 CR 035. I think that covers everything. Ms. Contour, is there anything else for the record that I...
Your Honor, for the license suspension, does that begin on the date of the offense or today?
What was, has his license been suspended? If there's no ALS, then it starts today. If there's an administrative license suspension, he'll get credit for that, but...
I would have to look, Your Honor.
It would start today, is my understanding.
Okay.
Unless it's been suspended. The fact that he hasn't driven, that doesn't get credit for that.
Okay.
Mr. Watson, anything else?
Nothing further, Your Honor.
Thank you.
All rise.
Good morning once again, everybody. It's a Monday here at the Courtroom Files Live, and it's definitely treating us like a Monday. Once again, we lost connection there for a second. Apologies. I'm just going to ride with the backup connection the rest of the way. I tried to get us to the good one, and it just failed on me again. Normally very reliable, but not today. Let's go to Texas. We'll say good morning to Judge Stevens.
Already? What's going? Y'all been talking? You've been working with him? When was the last time you spoke with him? A month ago, and we're in trial today. My God.
I have been trying to get a hold of his office, and it like says they get the phone number is different. And I also tried to message him, and I'm doing very nice.
It's a trial today. Yeah, but y'all haven't also, All right, y'all, I mean, we can go to trial right now and we're ready.
It's only Fridays from 1 to 4, and I've tried to call and I haven't got anything. Yes, I did. I was like, not this.
It's the day for trial, you got to strategize and prepare and, rehearse your testimony.
Letter and you phone call from me.
You didn't even know you're going to be under oath.
I didn't get anything from him. I didn't get any letter, any phone call.
I'm sorry.
I didn't get anything from my.
That's not. Yeah.
But that's how I had got my whole Stephen shot. That's how I've always gotten hold of him.
Cheers, texting and Facebook Messenger.
You know what I would say. I've done this for 40 years and I've never come to a trial without being prepared with a meeting.
I'm ready to try. I'm not.
She hadn't talked.
No one told me anything about the trial.
She says she's surprised there's even a trial today.
The boss was responsible.
You're not? Her lawyer is not?
I do my best.
What have you done? Oh, no. Okay. All right. Well, I've never heard, this is completely, I've done this for 45 years and I've never heard of such, never heard of this.
I didn't hear until
People get
today.
ready. And then what they said last week when you weren't here at trial docket. So we had a trial docket, you didn't even show up.
I was in the trial.
Sir, you interrupted me just then. Sir, you interrupted me when I was speaking to you. Sir, I'm speaking to you. I didn't finish my sentence, if you'd be so kind. We had a trial docket. You never showed up for the trial docket, and the people there said they hadn't talked to you in 4 months. And it was obvious y'all weren't going to be able to go to trial. We had to go to trial on another case.
I had to put a notice of order from Judge Starkers because I was in trial.
Sir, once again, those are things you need to speak to me directly for, because the protective orders, look, we know what's going on with protective orders. And this court has a fair opportunity to be heard on its protective orders.
It wasn't a protective order.
Well,
I did pick a jury.
This court generally doesn't do that, but I know some courts do. But I'm supposed to find out way ahead of them. I should know way ahead of the trial when that's being pulled, because the courts have a fair opportunity to be heard, especially ones that don't do the protective orders like I do. I know what goes on, and in some of the counties, it's subject to abuse, and that's not fair to the people who are the 22nd largest county with the 16th highest crime rate, like ours. I think we have some prioritization for the people of Jefferson County. You can't go to trial right now. Y'all aren't ready for this.
They tried, but we didn't know when, and that's the
Yes,
first thing I heard.
Okay, well, there's got to be preparation, and you just can't impromptu come up here and start testifying. It has to get rehearsed and things like that. Y'all just be seated, please. Y'all can be seated. Yes, you can be seated.
Just
All right. No, what good would it do? It won't do it. There's nothing that really can be done about it. It won't help it.
So yeah, Judge Stevens not happy with that. Don't know if I blame him, because it sounds like the lawyer just kind of pieced out on everybody. That's how I took it. So yeah, that's a problem. Barbara, thank you for the 5, by the way. I forgot to say thank you earlier. I very much appreciate that. Ellie thanks you as well. I'll keep an eye on Judge Stevens. Let's switch it up again. We don't get to go here often. Fulton County, Georgia. Let's go into the state of Ashley and spend a few minutes with Judge Alex Manning.
Situation, it seems like he's picking up his children. Just need to make sure that that's okay by the courts. It's not in the current bond order that we have.
Okay. What do you say, Ms. Collins?
Judge, I'm not sure if there is a child care exception, but we will look into it. I just need to get my laptop to pull it up, Judge, but I'm not sure if there is a child.
Yeah, let's see. Mine's just signed into Odyssey, so let's see here. Da, da, da. So do you go get the child all the time?
Like when her mom worked late,
Uh-huh.
I have to go pick her, that's all.
All right. And where do you have to pick them up at?
She go to the school out from McDonald. It's called AU
Right.
Academy.
So you didn't see it in his bond? I know it's just kind of spinning. Well, I'll tell you what, how about if it's not in there, that we'll add it. Any objections to that, Mr. Jenkins?
I apologize, Your Honor.
So for he can go pick his daughter or his child up at childcare. Sometimes he said when his mom's working late, he has to go get her.
All right, I don't have any objection to that,
Okay.
as long as there's the proper notice given to the ankle monitor company.
All right, we can add that. So what do we have, Bostic, anything?
No new arrests, added on for over 2 years, 2.5 years, 5 times.
And I believe we have a motion pending, we just haven't been scheduled yet.
Same thing. I'll ask Judge Williams and see, because I don't see anything scheduled on his case at all. So I'll ask Judge Williams and I'll email Ms. Collins, okay? And if so, you just have to go by second chance.
Okay.
All right, thank you.
All right.
She says whenever you
Have a good day.
child up, you need to notify them of how you.
Chair Embry,
Yeah.
Chair Embry.
That's my case, Judge, I'm sorry. He has texted me and said he is on the way.
Okay.
But if I run out and check on him.
No, go ahead. All right, I got Roderick Wimby.
Good morning, Your Honor. That's my client. I spoke with him yesterday. I'm expecting him to be here. I would ask if we could hold. I'll check on him and see where he is.
Oh, absolutely. All right, what about Patrick Freeman?
That's correct.
That's Freeman.
He intended first offender.
All right.
We're finding 10 years probation.
All right, let's see. Frankie Intieka. How was that decent? How do you pronounce it? It's what now?
It's Intieka.
I was kind of close. I mean, a little closer than I thought. All right, coming up. What we got there, second chance?
Your Honor, we don't have any current violations for this defendant. Start at 8/24.
Bostic.
Only prior arrest and he's been over a year, 10/8/24.
I know there's a status conference on the 18th. Is there been a motion filed to remove his?
I do not, I don't believe so.
All right, I can ask Judge Carnesell. So if I don't hear from her by the end of the day, you have your lawyer, just ask Judge Carnesell. Okay, thank you, sir. Have a good day.
You too.
All right, Leroy Hinton. Leroy Hinton.
Subject to good notice, Your Honor.
All right.
Your Honor, just so you know, we were on a compliance in Judge Williams on 12/10
Mm-hmm.
for all of the violations up until that point, and he was allowed to remain on the monitor and out. Just so you know, we did have a compliance hearing separate in Judge Williams.
Okay. Zachary Haas.
Barbara, thank you for another 5. Very much appreciate that. And one thing I wanted to note, isn't it interesting how these different judges work? You know, we've got clients here in Judge Manning's court who haven't showed up, and she's like, yeah, go check on them. I'll pass it, whatever. If this was in Judge Simpson's court, he'd already have a warrant out for their arrest, and he'd have the Washtenaw County Sheriff's Office tracking them down. It's so weird how it works.
Jimmy Holmes. One more. Mr. Holmes is here. Was this one on there too? Was this one on Williams' calendar too?
I apologize, Your Honor, what?
I was asking her, was this one on Williams' calendar also?
No, Your Honor, we did not.
Oh, okay. Well, go ahead. How's Mr. Holmes' second
We
chance?
don't have any current violations for Mr. Holmes.
Bostic.
Been out since 6/22/23, no new arrest.
I didn't see anything coming up, Ms. Collins. Have you filed a motion with this one?
Yeah, I filed a motion for both cases and we're just waiting on a date.
All right. I'll email Judge Williams too, see what she wants to do. All right. I'll let Ms. Collins know if Judge Williams wants me to go ahead and remove it.
That we filed a motion, but only Judge Williams can remove it, so we're just waiting for dating Judge Williams. She said she'll reach out to Judge Williams. Okay.
All right, thank you. Let's see, Quintavious Thornhill.
That's my case as well, Judge.
All right.
Also on his way.
Okay, all right, we'll come back. How about Demetrius Hatcher? I think he's incarcerated.
On the SP, I think on this case, 24, 25.
Did they bring him over? All right, DeAndre Middlebrooks. All right, Alejandro Ruganis. All right. What do we got there for, number 22?
Your Honor, we have no current violations, but there is a stay away listed on the bond order, but no address given. If someone at the court could provide that at some point, that'd be great.
I'm assuming I didn't do that, Bond.
I think you're correct.
Let's see. What about it, Bostic?
That's this 10/9/23, only you arrested for a probation violation in April 2025.
All right, let's. Let me see if I can find that. Thing's kind of slow. All right, we'll try it. I'll find that as soon as it comes up and we'll put the address down there. I'm assuming you know which address you're supposed to stay away from?
Yes, ma'am.
Okay, so don't go over there, okay? We're gonna add it to your bond conditions. All right, thank you, sir.
Do you know if I'm supposed to call the pretrial lady today after this court?
Are you supposed to call him?
Well, yes, ma'am.
Bostic says yeah.
Okay.
All right, thank you.
Judge, may I be excused?
Yes, ma'am.
Thank you, happy holidays.
You too. Perez?
So judging from the current stats I'm seeing right now, there's probably a bunch of new viewers out there this morning, both on, well, honestly, on all the platforms, on YouTube, on Kick, on Rumble. So feel free to say hi in the chat. This is a very friendly community, so reach out, get to know them. They'll treat you well here. We'll spend a few more minutes with Judge Manning.
Thanks. Thank you, Judge.
And if you just send it to me,
Are you Virginia Perez?
Mhm. And if you just send it to Mr. Jenkins, if there's anything I need to sign, I'll do it. All right, ma'am, thank you. He says he's gonna send over no price, so later, okay?
I'll email up at DEC.
Yeah,
It's done after today, right?
it'll be done. Do you have an ankle monitor on?
Post?
Do you still have an ankle monitor on?
Ma'am.
You still have your ankle monitor on?
Yes.
Yes. We're gonna get an order, this is the case probably today, and then you can take it off, you take that in the living room.
So it's not in yet.
No, it hasn't been processed yet, but he emailed it yesterday.
I'm gonna go home and come back all the way fast.
Stay with her. Walk with me to the 5th floor, we'll talk across. I'll take care of it.
All right, no worries. D'Angelo Gray. About Imari Lewis. All right, come on up, Mr. Lewis. All right. Good morning, good morning. What about, second chance?
Your Honor, we don't have any known violations. Also has a stay away zone. We are unaware of the address listed on the bond order.
All right. I'm assuming that you know the address they want to stay away from? Okay, we'll get that address added as soon as it comes up.
Oh, I don't know the exact address, but I know where it's at.
Okay, let's see here. Let me look, see if I.
And they're actually. Sorry.
Bostic. All right, let's see, dude. Let me see. All right, so let's see. I'm sorry, it's slow coming up. Let's see, 1 second. All right, it looks like it's 540 Windsor Street Southwest.
Thank you, Your Honor.
Okay. And nothing, Bostic?
No new arrests, been out since 9/2024.
Okay. I'll email Judge Cox too. I didn't see it coming up on any sort of calendar, but I'll email him, see what he says. All right? Thank you, sir.
Okay.
Timothy Banford. All right, come on up, Mr. Banford. All right, let's see. What about a second chance?
Your Honor, we have a plethora of dead batteries, 11-5, 11-7, 11-13, 11-19, 11-20, 11-22, 11-24, 11-25, 11-30, 12-1, 12-3, 12-12. We also swapped the monitor on 12-10. Apparently it fell off out the job. But very inconsistent with the charging, not allowing it to get fully charged and then not charging every day.
All right, Bostic.
No new arrests since 3/17/24.
All right, what's going on with it?
I had started working at UPS now, so, and we've been doing like 6 days a week, like 10 to 13 hours. So when I got out of work, I just forgot to charge it.
That's a lot of them though. So I could tell you right now that if I called Judge Farmer, he'd say, put you in jail. I don't want to do that, okay? So what can we do to help you so you can get it charged? It's 1 hour in the morning, 1 hour in the evening. That's all you got to do.
I just got to remember to keep it charged. That's it. I try to keep it charged.
All right. If you're in your car driving, you can probably get some one of the things you can plug it in and charge it while you're driving or something. I don't know.
Yeah, the UPS truck ain't got like the.
Oh, a thing?
Yeah, it don't have no type of power source in there.
Are you driving the truck?
Yes.
Oh, yeah, I don't know. So just try to keep it. I understand this is season. It's going to take you a long while, but just try to keep it charged, okay?
Yes, ma'am.
All right. Let's see. Tyler Cole. All right. What about Mr. Cole? Second chance. What about Mr.
So, Your Honor, the device was dead from 7/8/25 until 10/23/25 when he came into one of our offices, and it was the back plate was put back on, and then it died again and didn't charge until this morning at 12:36.
Boston?
Been out since 10/30/24. The new arrest was for driving with a suspended license 7/25/25.
All right. Go ahead.
Judge, we have, the case is indicted to Ingram. We've had arraignment. We have final plea in like 2 months.
Yeah.
I know that he is employed and works in the film industry as well. I know he's got a movie coming out. So I don't know, the reasons that it wasn't working or why the backplate fell off, but I'm in communication with him. I don't know that he's had any violations other than the device not working itself.
So do you think it's just not charging? You need another one? You need a new one? Go ahead.
Yes, ma'am. Like Brian said, I'm an actor. I'm in the film industry. So I do stunts and things like that. So it has broken a couple of times for me doing stunts, but every time it has broken, I've called second model and got it replaced. Now, I didn't know that it wasn't charged from 7 a.m. I put it on charger every day, so I don't know why it's not charging, but they haven't never called me and told me I was in violation of anything. And every time I go up and get a new one, they never tell me that it's not dead or anything. The first time that they actually told me that it was dead was my last time that I got a new back plate and they told me to charge it. But anytime previously before that, I've never been told anything about my thing being dead. And when I came last time to you, I was good then too. I didn't have an issue with my thing before.
So how much did it charge this morning, or does he need to swap it out? You don't see if we need to swap it out. You had it on. I'll ask Judge Ingram too, see what she says.
Yeah, I believe he's been on it for about 14 months.
Yeah.
That's it?
14 months.
Yeah. All right, I'll ask Judge Ingram, not email you and let you know that, but she's gonna see if it needs to just be swapped out or.
We're at 80%, Your Honor, so.
So it's charging now, okay? But just do what you can to keep it charged,
Okay.
all right? And I'll email Mr. Tevis and let him know what Judge Ingram says, okay? And then if they take it off, all you gotta do is go by second chance.
Okay.
All right, thank you, sir. Have a
Judge.
good
I
one.
appreciate it.
So that becomes a question there as to how they handle that. So he's a stunt double. He's got an ankle monitor on. So do they put an ankle monitor on the main actor and just write it into the script that the character is on an ankle monitor, or do they take it out in post? These are the questions. These are the questions we come up here with at TCF on a Monday. Let's change it up. Let's go to Texas, 9 to 11% more. Judge Boyd, as we promise.
Just 1 second. Here. It's just here. Right. Cindy, are you ready?
Yes.
Court is calling 2024 CR 09126. This is a motion. It's ex parte Shelby Rodriguez. Could I have parties announced, please?
I'm Attorney Keith Gross. I represent Anthony Rodriguez, Your Honor.
Amy Owen for Shelby Rodriguez.
James DeWiggins for the state.
All right, and Ms. Rodriguez is not present. Do you waive her appearance?
Yes, Your Honor.
All right, so we're here. There was a jury trial that was held. The defendant was found not guilty. The defense requested an expunction. The court granted the request for the expunction. And then a motion was filed. I'm sorry, what is your name, sir?
Keith Gross, Your Honor.
By Attorney Gross, requesting that a motion for a new trial on the granting of the expunction. Is that correct?
Yes, Your Honor. We did that in addition to a plea and intervention.
Right. And then there is also, let me see. And the other motion I had for you, there was a request for attorney's fees. That is not a part of this, correct?
No.
Okay. All right, then the court will hear your argument, counsel.
Thank you, Your Honor. As the court knows that Ms. Shelby Rodriguez was found not guilty and acquitted. She filed through her attorney a request to have the records expunged. My client, he in his intervention in new trial, he didn't get notice of the expunction trial and petition. This court granted the expunction without my knowledge, my client, Anthony Rodriguez, his knowledge or participation. There is and has been an ongoing family custody dispute in the 73rd District Court under cause number 2023 CI 24233, in which custody of minor children are at issue before the court. During the course of the investigation and the prosecution of the criminal case, the police had gathered several records, including interviews with Shelby Rodriguez. They had taken pictures and statements from her.
Okay, and sorry to interrupt, but let's start here. Number one, you stated you didn't have notice. The first question for the court that needs to be answered is, because this is a criminal court, that's a civil court. The first question was whether or not you were entitled to notice.
In the expunction proceeding is a civil proceeding. My client has a legitimate justiciable interest in the preservation.
Based upon what? Because according to the law, and if I'm incorrect on my understanding of the law, let me know. But according to the law, the only party on a civil side that can intervene and request a notice of expunction, or that an expunction not be granted, is the state. Am I reading that incorrectly?
No, that is absolutely correct, Your Honor. And I would push back against him saying that it's a civil case. If it were not within the 30 days under the purview of this court, it would be a civil case. But that's why it was filed under the criminal case number in this case, because it's an acquittal expunction that falls under the authority of a criminal court.
All right. So first things first, does everyone agree that with regards to expunctions, if there is going to be an intervention or a request that an expunction not be granted, that's to come from the state?
That's my position.
I disagree, Your Honor, because
Well, let's pull out the code.
Your Honor, his motion is under 55A.302. And if you look at,
Just 1 moment.
sorry,
You say 55A
yes, 302.
.302?
Yes, sir.
All right, so here we are. Article on the Code of Criminal Procedure, Article 55A.302. Of course, there are certain reasons or legal reasons a state may ask that a acquittal not be granted. One is if there's another pending criminal case. So Attorney Owens, is there another pending criminal case against Ms. Rodriguez?
No, Your Honor.
So that falls. And it says, in the case of a person who is the subject of an expunction order or the basis of an acquittal, the court may provide in the expunction order that the law enforcement agency and the attorney representing the state retain records and files if, one, the records and files are necessary to conduct a subsequent investigation and prosecution of a person. So there's no other pending prosecution. Or two, the state establishes that the records and files are necessary for use in A, another criminal case, that's out, or B, a civil case, including a civil suit or suit for possession or access to a child. So it says that the state has to establish this. Otherwise, what could happen is whenever there's an acquittal and somebody wants an expunction, anyone can come in and say, I don't want them to have an expunction. So according to my reading of the article, the state has to establish that the records and files are necessary for use in a civil case. State, have you established that the records and files are necessary for use in a civil case?
No, Your Honor, and we would only do that if we needed it for, say, CPS court, which we were going to go forward in a lower burden. But again, that would be something that we intended to do. We have no intention of doing so at this time.
Your Honor, the argument would be that Article 55A.302 does not preclude somebody else from doing it, meaning only the state can do it. It doesn't say that Mr. Rodriguez could not come forward and say, we have a legitimate interest in seeking this. Well, the evidence, we've got most of the state's exhibits, or not the state's exhibits, but the exhibits used from the criminal prosecution. But my client clearly has a justiciable interest in maintaining and having access to those exhibits for the civil litigation.
So your argument is that anyone who's involved in any civil case can intervene or is entitled to notice of an expunction, just anybody?
No, not anybody, but in the case, my case, it would be the spouse, where the spouse was an alleged victim of family violence, where there's an ongoing proceeding involving custody of the children. I don't think there's a dispute here that there's a civil case involving the husband and wife, involving Shelby Rodriguez and Anthony Rodriguez, that has to do with the custody of the children. And in this particular criminal case, it was alleged that she committed aggravated assault when she pointed a gun at his head and
She was found not guilty of that.
and I understand, but in this family matter, the level of proof isn't preponderant, isn't proof beyond a reasonable doubt. It's preponderance of the evidence, and it's still.
And are you seeking to terminate her parental rights in
No,
the?
Your Honor.
Okay, well, here's the thing. The code is the code. That's what we follow. And if the legislature wanted it to include the state and other parties, it needs to say the state and other parties may. It only says the state. Ms. Owen?
I join in the state's argument that she should be granted the expunction. I mean, it's just a backdoor way to sort of annihilate her in the divorce proceedings. And the other part of it is they requested police reports and body cams and all that stuff. So they already have everything the state's destroyed.
And I have a issue to address regarding that as well.
Yes.
Well, one of the things he's asking for relief for is for you to determine that the things they already have may be used in the custody proceedings. And for that, I'd like you to turn to 5503, where it says, when the order of expunction is final, the release, maintenance, dissemination, or use of the expunged records and files for any purpose is prohibited. For the next one, it says, under subdivision 3 of this article, the person arrested may deny the occurrence of the arrest and the existence of the expunction. And when questioned, they only have to say that it's been expunged. And then an offense under this is a Class B misdemeanor. So to produce these records in any other way once it's been expunged would be a criminal offense.
And that's why we're here today, Your Honor. I believe there's more to that statute.
Just one moment, I'm sorry.
Yeah, I completed it. The other one in the Bible.
Thank you. All right.
Couple things.
Mhm.
I do remember reading where the dissemination of this material for money was a criminal offense. Nevertheless, the reason we're here is because, not because I need the state, the police agencies, or to preserve their records, because we've gathered almost 90 exhibits to be used in the civil case before.
But no, let's backtrack a little bit. Because when cases are expunged, they're expunged. And the defense's argument that it is a misdemeanor to still disseminate records, that's correct. That is why when they do the expunction, they ask that the person be removed, all police reports, the fact that they were placed on bond with the bondsman, that's removed. Whatever the defense attorney or the person who's requesting an expunction puts in their order, then those agencies have to remove from their databases any record that this even existed, that the offense even existed. So it's not just for specific purposes that you will be held liable criminally if you were to disseminate information. Once you received it and you are aware, and usually they send it out certified to different agencies, then it's expunged, it's removed.
My client wasn't served. We're not a party to that list of people that were served with the expunction. We did find out about it. I think opposing counsel had produced it to us, but we were not on a list. In addition, that would also support my argument that my client deserved notice and a hearing, because if the state or opposing counsel is going to seek to prohibit the use of these exhibits at our family trial, then obviously I think she has a legitimate.
But when you file expunctions and your request for expunction, it is not involving several parties. It's involving the person who's seeking the expunction. That's why it's ex parte, whatever it is. So when someone's seeking an expunction, and counsel, feel free to correct me if you think I'm misstating the law. But when someone seeks an expunction, it's because they've been acquitted, either by a judge or a jury, they've been found not guilty. Now, according to the code, It says the state must establish that the records in the files are necessary for use in, and it says another criminal case. Both parties have said there's no other criminal case in existence, or a civil case, including a civil suit or suit for possession of or access to a child. But it's the state who must establish that. Separate parties or individual parties cannot.
If I could shed a little light on this situation, Your Honor. This comes up quite frequently. For instance, if there's a police officer accused of a crime, police officer goes to trial and then is acquitted. The records, the investigation, all the state's files are expunged and destroyed. However, when it goes to arbitration, if internal affairs spoke to him, the internal affairs investigator is allowed to remember his conversation. His client is allowed to remember the events of that night as his client sees it. You can't expunge memories. So all those people can be subpoenaed, but the state's record, the state's hard evidence, that is what cannot be disseminated and used. Does that make sense?
Yes.
And Your Honor, for example, there's videos taken from the police officers when they went into the house, interviewing Ms. Rodriguez, where she made certain statements, including being suicidal, admitting to pointing the gun at this person, and that evidence has been contradicted by her, and it would be subject used for impeachment purposes. Also, some of this evidence had already been used by, I think his name is Dr. Thies, when he did a family custody evaluation and a psychological evaluation. So now, if this court's ruling, which would, I don't know if the court intends to enter a subsequent ruling saying you can't use this in the family case. I don't know.
All right, this is what the court is saying to both parties. And I want everybody to understand me, hear me clearly, internalize what I'm saying. Number one, your client as an individual does not have a legal right to intervene into an expunction in a criminal case. Your client does not have standing in a criminal proceeding to establish that he should intervene. I'm just following the law. What you all do on the civil side and whether documents can be used on the civil side, that is completely up to the attorneys over there. What I'm telling everyone, she was found not guilty by a jury. The defense requested an expunction, which legally they are allowed to do because she's found not guilty. The court signed that expunction order. That expunction order will still stand. What you all take that expunction order to mean on the civil side, that is for attorneys to discuss on the civil side with that judge. My only ruling is she's found not guilty. I accepted the verdict from the jury. The defense filed a motion to expunge. I expunged it. Counsel, I understand why you would want this information, but the court is bound by the law, and the law says you're not entitled to it. The law states that the only person who can bring up or establish that records are necessary is the state. And if people want to change what the legislature has done, then you all need to write the legislature.
The last thing, Your Honor, that begs the question is, being that the state is aware of the family proceedings and there's no dispute that civil litigation has arose out of custody, why hasn't the state joined in the motion? I mean, is it just arbitrary and capricious? They say, no, we know it's going on, but we don't want to ask the court. It begs the question, why would the state take that position?
All right. So this is what I can tell both parties. And please internalize what I'm saying. Number one, if the state wants to intervene in your motion right now, it's too late. Time has expired. Number two, the only persons who are allowed to establish a record stating that this expunction should not take place and who can intervene is the state. And that's what the law says. That's what the code says. If the code said something differently, if it said, you know, individuals who are in the middle of a custody dispute are entitled to intervene, then I would have already known about that. And I would have made different rulings, but that's not what the law says. So the motion or your petition for intervention, that's denied. We can go off the record. Whatever you all do on the civil side, as far as if there are some police reports out there, that's for you all to argue on the civil side and argue before that judge, whether or not that should be allowed or whether that's a violation of the law. All right, is there anything else?
Thank
No,
you.
Your Honor.
All right, thank you so much. Thank you.
Maybe be excused.
Yes.
Thank you.
Well, that was fun. As somebody stated in the chat, there's always something new and different here at TCF, and we haven't seen anything like that before. Good legal argument, good fun to watch. That didn't involve somebody going to jail for 127 years for a crime that we hate to speak of. So that's always fun. Let's stay in Texas, but we'll go back to Judge Stevens, new contestant.
Where's Danny? That's you? Yeah. Okay, let's take care of Mr. Johnson here. Okay. 24 CR 1670. The state of Texas versus Danny R. Johnson Jr. That's you, sir? You are here with Mr. Dusler, your attorney, and the state's attorney. There's a first amended motion to revoke unadjudicated probation here that we're going to be disposing. Was that your understanding, sir? Please raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God. Does the defendant waive a formal reading of this first amended motion to revoke unadjudicated probation? Here can we proceed in summary? In summary, this motion in 24 CR 1670, it was handed up. It was filed on 12/3/2025. Okay. Are we ready? Are we ready?
We have an agreement, yes, sir.
Oh, okay. This was just handed up just a couple of weeks ago. You have some fair amount of time to prepare for any disposition. Are you ready to move forward on this, Mr. Johnson?
Yes, sir.
Do you, and you've talked this thoroughly with your client, with your attorney, you've discussed it. Does the defendant waive any additional time he may have under the law to prepare on and move forward?
Yes, sir. We're ready to go.
All right. And we can proceed in summary.
Yes.
In summary, this first amended motion to revoke unadjudicated probation states that on March 3rd, 2025, in this court, you were placed on 10 years deferred or unadjudicated probation for assault on a peace officer. Is that true, sir?
Yes, sir.
Is it 6?
That'd be fine. Sure.
Number 6 in this first amended portion states that you violated your probation by committing the second-degree felony of robbery on or about October 21st, 2025 in Orange County, Texas, which is in violation of condition 1 of your probation order. Is that true? Are you pleading true? Are you pleading true to this voluntarily and because it is true?
Yes.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment, which is no less than 2, no more than 20 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes.
The agreement has been reached where your probation would be revoked and you would be sentenced to 3 years. That's what that is, a 3?
Yes, sir. I'm sorry, the tablets,
I know. I know. We're going to make the Arabic pretty. So it's clear. Look like a snowman. Okay. 3 years in prison. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal. Do you understand?
Yes. Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Is everything true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, this states that you are waiving all rights of appeal if I follow this agreement, which I intend to do. All right. Anything else to add? I'm going to follow this agreement and find that there is sufficient evidence supporting this first amended motion to revoke unadjudicated probation, as the defendant has pleaded true to allegation number 6, committing the offense of robbery on or about October 21st, 2025 in Orange County, Texas, which violates condition 1 of your probation order, which is don't commit any offenses while on probation. And that is enough to, by preponderance of the evidence or greater, to grant this motion. Your probation is hereby revoked in this second-degree felony of assault on a peace officer. And I'm going to follow this agreement. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty, all when we placed you on probation in March of this year. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in that hearing to find you guilty beyond a reasonable doubt. Now that your probation is revoked, I hereby find you guilty beyond a reasonable doubt of that second-degree felony. I am following this agreement. You will hereby sentence to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You will be given credit for all time you have served in accordance with this case. You understand what has happened to those?
Yes, sir.
Anything else?
No. Make that a greater includes.
Okay, friends, let's bounce back over to Judge Boyd, new contestant there.
Just one moment.
Operator's on page 13, Judge.
All right. All right, so you all agreed on an amount, $3,700.
Yes, Your Honor. That's what the victim, there's a document in there that came from Target. Because this occurred at Target where he was employed. There's a document in there from Target where they, I guess, interviewed the defendant about the items he stole, and he admitted to the amount specifically that's requested by the state.
All right, so when are you going to pay for this?
I can pay payments over time, Your Honor.
So when you say you can pay for this over time, how much are you talking about per month?
A month I can pay 500.
All right, so can you pay 500 per month, or are you just telling me what I want to hear?
No, yes, Your Honor, I can pay 500.
Do you have employment?
Yes, ma'am. Yes, Your
All
Honor.
right. All right, court is calling 2025 CR 003791, State versus Andrew Xavier Crawford. Can I have parties announced for the record?
Melissa Albin for the state.
Keith Engelke for Mr. Crawford.
And are you Mr. Crawford?
Yes, sir.
All right, you entered a plea of no contest on September 16th. And according to this, he was to pay $500 already. So has he paid $500?
No, ma'am, he's not been able to do that.
Why not?
I get paid for my employment tomorrow, and I have the money today, but sometimes my check comes early, but it's not like always the same. Like, it's not always the same time, and I get paid tomorrow. I was gonna have.
State?
Yes, ma'am. He said that he would have the money today and, or by now, and he hasn't, so obviously that raises concerns.
All right, so here's the issue for the court. The issue is that this was set on September 16th. You entered a plea, and the court, you said you would pay $500 by the next setting.
Yes, sir.
So here we are in December.
Yes, sir.
So when are you gonna have the $500?
I can have it tomorrow. I can bring in the money to you.
All right, your bondsman did an affidavit to surrender surety. So what I'll do is I will, how are you paid?
Weekly.
No, I mean, are they doing those things where they give you a credit card or direct deposit?
Yes, sir.
All right, what I'm gonna do is I'm gonna send it to you today. And I'm gonna order that $500 be paid towards restitution tomorrow. If it is not paid, a motion to revoke will be filed. Do you understand?
Yes, sir.
All right, state you may be excused. Are you Xavier Crawford?
Yes, sir.
Can you raise your right hand for me?
Has a warrant.
Yes. All right, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, so what do you do for a living?
I work at BJ's.
Okay. And do you have any children?
No, you're.
Do you have family support?
Yes, sir.
And who is your family support?
Mom.
Right, do you live with them?
Yes, sir.
All right. All right, this is what the court is going to do. All right, Yaya? Yes, sir. This isn't a motion to revoke. Okay. Oh, that's okay. I'm gonna white it out. All right, and have you had any type of mental health issues in the past? All right, the court is going to sentence you to 5 years deferred adjudication. Just one moment. Oh, no problem. All right, the court is going to sentence you to 5 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 40 days, no employment as a home health care provider or with minors. There's to be restitution to Target in the amount of $3,746.99. And I don't know how he's going to pay the 99 cents because they're doing away with the penny. So $500 to Target that needs to be in a money order or cashier's check is due on December 16th, 2025. There's to be 200 hours community service restitution. Why is there a request for healthy relationships? All right.
My understanding is it will be taken into consideration.
All right, so there's to be 200 hours community service restitution. 100 hours will be deemed satisfied upon completion of the Healthy Relationships course, which I'm ordering. The remaining 100 hours will be deemed satisfied upon the completion of the anti-theft course, which I am ordering. And have you had any type of mental health issues in the past? All right, there's to be no contact with Target. That's any Target. So don't go to any Target. Or Michaela Pean, Pean. There's to be field visits 1 time per month for 6 months. With regards to a case to be taken in consideration, it's not in your plea bargain agreement.
It's my understanding was to be.
I mean, it's not listed. State, is there something that's being taken in consideration? Okay.
I can provide you with the case number.
Well, no. I'm just saying what your plea bargain agreement is with this court. There's no TIC. If the state is saying there's a TIC, then the court will, of course, follow that, but that's not in the plea bargain agreement. Probation, is there anything else that's needed? Is there anything else you need from the court in order to be successful?
He has a setting on the outstanding misdemeanor today.
All right. And could somebody look and find out, is he taken into custody because the bondsman did an affidavit to surrender surety for this case?
He was supposed to come to sentencing in October 23rd. And then the affidavit surety was filed.
Okay.
He failed to appear.
And I issued a judge's warrant and remanded with you without bond on October 23rd. Why did you not appear?
Because I had an accident.
Because what?
Because I had an accident in the morning.
An accident what?
An accident in the morning.
What type of accident was that?
I was taking my brother to school in the morning for my appointment, and I got rear-ended
And did you inform your attorney of that?
like hours later.
The court didn't receive notice of that, because if the court would have received notice of that, the court would have recalled the warrant.
Yes, sir.
So what information did you tender?
I didn't tender.
The judge, he called me, I appeared, I notified you. You asked me where he was and some other questions. And I tried to obtain information from the clinic, and the clinic sent me the document that I could not open. So, and then Norma indicated that she would just reset the case.
Normally what?
The coordinator indicated that she would reset the case to a different date. And
I usually have request information. In order for the case to be.
right, and we did furnish a request from the clinic to excuse him from court. And I believe you indicated to the coordinator if that wasn't sufficient. So I tried to get something more.
No, I mean, in this court, if somebody says they've been in an accident, they need to provide documentation. So my question is, was documentation ever provided to the court?
Beyond what I just described, the request from the clinic, no.
All right, so, yes.
I just want to let the court know that he does have a misdemeanor harassment case, and as part of the agreement that Megan made with defense counsel, it's to be judgment satisfied, not TIC.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand, counsel?
Oops, sorry.
All right, so the court will recall the warrant since this case is closed. And I'm only recalling the warrant for cause number 2025 CR 003791. So if he has a warrant elsewhere, he needs to take care of that. All right, good luck to you.
Thank you, Judge.
And you need to have that paid. Otherwise, a motion to revoke is going to be filed.
Yes, ma'am. And where do I bring it? Where do I bring it?
You speak to probation and they'll let you know. Thank you. You're welcome. Who's next?
Okay, friends, it's a Monday here at the Courtroom Files Live. I hope you're all having a good day so far. Just a programming reminder, at the top of the hour, we will be ending the show. I can only do 2 hours this morning due to other business commitments, so just bear that in mind. I was going to switch courts, but a new contestant just walked up. Let's stay here.
Some things. Right now, there are about 8 or 9 items that I still need in discovery for test to my plan that we either entertain or make a counter offer on plea bargain. So that's kind of where we're at.
All right, Ms. Ferguson, recall this for that first week in January. Put it on a Tuesday. We'll come back on January 6th. That's the plea bargain agreement or jury trial.
All right.
All right, thank you. And they'll have you brought over dressed for trial on that day. Thank you. Who's next?
Okay, now we'll switch it up. Let's go back to Georgia and Judge Manning.
All right, Valencia Springer. Tariq Brown. All right, Mr. What up, Mr. Brown? All right, what do we get for Mr. Brown?
Your Honor, we're just getting curfew violations, about 30 each month in September, October, November, basically arriving home late. So I'm unsure why.
Well, no, late is late, on time is late, et cetera, but how late is it?
Couple of hours.
Oh, okay, so it's not like stuck in traffic. So what's happening, Mr. Brown?
Good morning, Your Honor. Mr. Brown has a second job pretrial is aware of. Pretrial filed a mini compliance report a few days ago saying that Mr. Brown texts them every single day when he goes to work and when he returns. That's for both of his jobs. So I think it might be an issue of communication between pretrial, under which Mr. Brown is on ISP, and the ankle monitor company.
So then what can we do to keep it, to make it so he can be in compliance? He's what?
I'm telling him he's supposed to report when he's leaving from there, he's at work, not pre-trial support for the ankle.
Okay, so that hasn't been his understanding for the past 13 months and 11 days.
I'll check with him, but
Yeah, when he was here on June 16th, before Your Honor, they said he had absolutely no violations and he's had the same work schedule the whole 13 months and 11 days he's been out. I think a solution for any concerns the court has might be I filed a motion with Judge McBurney because this is an indicted case under 25 SC 006600. I'm asking to remove the ankle monitor because it has been 406 days, and according to pretrial's report, he's been in perfect compliance.
But just not with ankle monitor. So what is his, let's see, I'm trying to see what his bond conditions are.
We have 24-hour except for work, medical, for himself, court, and attorney.
So do they have your schedule? Do you have a normal schedule?
Yeah, I got the same schedule for both jobs.
Okay, so when you're late, is it because gotten off at that later and then you get home?
Yeah, so the second job, I'm like the manager, so I have to stay and make sure things are put in place for the next day. Or we just staying talking or counting money, anything like that.
Okay, so have you sent Second Chance your schedule?
I gave it to Miss Hicks and she was aware. I was always under the impression that she communicated with them. I didn't know.
Who is Miss Hicks?
My pretrial officer.
Okay, now, so stuff needs to be communicated to Second Chance for the ankle monitor.
Okay, well,
I'm contact Ms. Hicks to see if she's supposed to be reporting on him, and I'll let you know what his action's supposed to be.
Okay. It sounds as though the ankle monitor company expects him to be back from work at a certain time, so they have some sort of schedule, and he gets there late and he gets home late because work is over, and he reports it to Ms. Hicks.
I think if you send them your schedule and then say, I'm the manager closing up, and then you like email them when you leave there and start, because they can tell where you're at and what time you leave.
Yeah.
Because if they checked it right now, I'd say you're at 130, 185 Shirley Franklin. All right, so just like some sort of schedule on that one, just let them know. You can get his card, so she's gonna give you a card, that way you can email them and let them know what your schedule is. 406 days?
Hold on.
Yes, Your Honor, and actually, Judge McBurney's staff said that you would be hearing our motion today.
Oh, he did he? I'm McBurney. All right, if you just if you hold up, then let me get through these other things. I'll do it real quick, okay? See who else is here. I'll hear yours. All right, let's see. Do we got Jonathan Finney? Come on up, Mr. Finney. All right, it's number one. What do we got on Mr. Finney?
Do it again, I'll take the time in 4 years.
What we got on Mr. Finney?
Your Honor, we have a stay away of 4610 Tucson Trail. Appears to be a park, maybe. And in that general area, Mr. Finney is there quite often. Sometimes hard to distinguish if he's at the park or the neighboring house. It's pulling pretty consistently. 10:31, several hours. 10:29, 10:20, 10:21, 10:22. 10:18, 10:17, 10:16.
Oh, it's Hanukkah, so I don't want to put anybody in jail on Hanukkah during Hanukkah. So, but are you going to the park? Because it says stay away from the park. Does somebody lives near that park?
No, at times I get into it with my wife and I, or we'll have a dispute. I leave the house. Sleeping in park's the only place I know to be at. That's my community. I grew up around now, and the other times too. Reginald Smith. You can look up in the obituary, just passed in October. He from the community. We had the balloon release, things like that over there. Other than that, I have no reason to be there. I be in that community, yes, because my god cousin stayed literally 3 doors up. So I'm allowed to be at my god cousin's house. But other than that, during them times, I'm either sleeping at the park or doing time for just recreation because, like I said, we're having balloon release.
You get in a fight that often with your wife?
Ma'am.
You get in a fight that often with your spouse?
Hey, best way I could put it is everybody fight demons sometimes, but sometimes two hurt people, two broken people come together to heal each other. So when she gets in her mood, the thing for me to do is do this. I see you in 24 hours. Don't go to my mother's. I don't like being at my mother's, but unfortunately I have to now because she just had a stroke and another aneurysm on Friday.
So what can we do so it won't show up? I hate that you have to sleep in a park.
I'd be having nowhere else to go, and that's where I'm most safe is at, because anybody can drive through there and see that it's a little generator, ain't nobody gonna bother me.
I'm trying to see where it, is it the bond that was on the 2022? Is that the one he got on? Wait a minute now here.
I've been on bond since 2022.
This one, let's see him. Man, who did all that specific stuff right there?
I had a female who stole my money because I would not have sex with her. Seriously. That's why I'm fighting for my name. And since then, I've become a building operation engineer, $72,000 employee guy.
All right.
The last arrest I had in April was because my mother and I put a civil lawsuit against Abernathy Towers, and they retaliated. And that's how come I was locked up April 21st of this year. They retaliated and cost me my job.
All right, so this is, that's a 4610 Tucson Trail. So is that the actual address?
I think that's the address of the park, Tucson Trail Park.
I think the judge that did that probably paid attention to everything. What do you think, Mr. Jenkins, what do you think?
I don't have the history in front of me in terms of the case itself. If that is, and I'm not in the position to, this is the Judge Cox case, is that correct?
Yes.
So, I don't know what, if the order is, and who his defense attorney, in this case, there's an order that he stay away from the park, and I don't see any factual reason to change or deviate from that at this time. Now, I applaud him for not, wanting to escalate any matters in his home, but that's simply still not an alternative. And so,
okay, so bottom line, no matter what happens, I'm screwed. So if anything like that happens,
sleep on the sidewalk, or bottom line, someone who's close to me, who raised me, dies, can't be there. I got you. Until they law give me my name back, these are the things that men have to go through, because that's all we got. I'm fighting for my name.
I got you. All right, so just keep it charged, and, I mean, if you have to sleep and you're sleeping close to there, at least email them and let them know.
Hey, I'm the support system. I'm the youngest of three, I'm the one living. I have nobody.
No, email Second Chance.
No, I email them.
What's that?
I said, I'll send them an email.
Yeah, I mean, if somehow you're out for the night and you're gonna, then just let them know, okay? All right, thanks, sir.
Mr. Finney, before you leave, can we just confirm your phone number?
404.
40450.
All right, let's see, Cleveland Lambert. Yeah, that's still not here. We'll check, we'll hold it for the,
Yeah, I mean, obviously, all of those who have not appeared, obviously subject to good notice, starts requesting a bench more fine forfeiture.
all right.
Not
so
to be effective until the end of today.
And we don't have Francois Garcia? Well, then it needs an interpreter. Second chance, just. Do we get an interpreter?
All right, we just have two. May I interrupt real quick? Is this Mr. Francisco Perez Garcia?
Uh-huh.
Yes. Okay, that is my, your honor.
Oh, okay.
Apologies.
No, I'm assuming you can communicate with him.
I have him as Mr. Perez, I'm so sorry.
All right, go ahead. Just two violations, you said?
Yes, your honor. So one was, on 11/27 was at home and then left and went to like a mall from 5:53 to 12:08 a.m. And then was in Nashville from 9:23 to 11:06, and did not follow curfew while there. Also had no prior knowledge of going to Nashville.
All right, so.
I did email them the address in Nashville.
Why does it say you need an interpreter? Who'd you email?
Second Chance. I got the emails there. It was with the permit to go out of town.
Yeah.
I emailed my bondsman too, to go out of town to work. So,
Did you copy your lawyer on there?
I
sorry?
believe we do not,
I mean, I'd always copy your lawyer on there so that,
just to make sure.
just to make sure, yeah, that you get it, okay? But if you go out of town for a certain time, I mean, send Second Chance like 2 or 3 emails. They'll get tired of emailing you, because some people email.
I have the emails and they're confirmed too. Do you need me to show them to you? I'll show them.
I mean, I'm good, but I'm just saying, if you do though, you still have to follow your curfew,
Gotcha.
okay?
Okay.
So, yeah, but just make sure they do, but yeah, I'd copy your lawyer too, okay?
Okay.
All right, thank you, sir.
Thank you.
We did actually have a quick question, Your
Uh-huh.
Honor. We were previously trying to communicate with the court about possibility of adjusting the curfew
Okay.
for matters of work or if not, just a removal of the ankle monitor, if that was possible. I believe we had mentioned or spoke about this earlier this year. I want to say June.
June the 15th, I think. I'm not sure.
Yes, June 15th. And I don't know if that was if that had been
Right.
evaluated.
All right, there it is, yeah. Oh, you filed that back in 2024. All
A
right.
while ago. And this was pre-indictment, of course, Your Honor.
Right, so what exactly is he wanting to do? Let's see, how do you want to modify it? 24 hours ahead of time.
Well, if at all possible, we were hoping that it could just be removed, but if not, if we could at least adjust it just for his schedule. That wouldn't be cutting it at short.
I'm self-employed,
Yes.
so I work from whenever I need to whenever I need to.
Okay.
Yeah, so your schedule kind of fluctuates, I guess.
Yes, ma'am.
All right. What do you say, Mr. Jenkins? So you do construction, you own your own business?
Yes, ma'am.
Too cold to work today, right?
Yes.
Yes.
Let's see, 10, 10, 20. So this says right now, so now what it is it was modified in October of 2024. And it says instead of the 24-hour curfew, it'll be a 12-hour curfew from 7 PM to 7 AM. Is that, you wanted it different from that?
If we could extend it to, say, 9 p.m. instead. Sometimes, I mean, we stop working, when it's summertime, we stop working till 8, 9.
Mr. Jenkins, could,
I have no objection as long as he can verify it.
all right, so what time do you go to work?
What time do we go to work?
Yeah,
From 6 to 9, depending on each job.
okay,
I
well,
have to
this,
send my schedule every time I have to go to work. I send them the address and then.
so what I'm saying is I'm trying to do this, but it says from 7 PM to 7 AM. So I'm trying to tell you what's most helpful.
I would say from 7 to 9,
Okay, so 9 PM,
9 p.m. to 7.
7 AM.
Yes, ma'am.
Okay, all right. Hey. No objections to that?
No, Your Honor.
All right, so we'll do that. Thank you.
Thank you, Your Honor.
All right.
Maybe I'd be excused?
Yes, ma'am. Have a good day.
All right, let's go back to Judge Stevens, fresh contestant there.
I didn't want to be in the bar.
The device was placed on hand, I believe it was October of last year. It's been 14 months. In those 14 months, there have been no violations of any kind. There's been no contact with the complainant. In fact, they haven't seen each other in over 10 years since their divorce in 2015. My client doesn't even know where she lives. There have been no prior offenses involving any kind of violence whatsoever in his history. And also there's the cost of the device, which is taking the toll on my client since these charges caused him to lose his prior job, and he's had difficulty making ends meet since then. But he is doing it, but just the cost of the device is taking its toll. And I believe mitigating all of these the device being placed on him are these factors that I just told to the court, Your Honor. He's here, he's come to all of the court settings. He has no intentions of making any kind of contact with my client, especially since these charges were placed on him. And we would ask the court to consider removing the device based on these factors.
Your Honor, given the nature of these charges, and speaking with the victim in this case, we do believe that there is a risk of contact. I think that this is a safeguard against that. He knows that he's being monitored right now, so he hasn't had any contact, and we would like to continue to prevent contact until this case can be resolved once and for all. So we'd ask that it remain on.
I don't think for that, I would just offer that I don't think the defendant is going to risk the consequences of such contact, given the defendant's familiarity with this court and the possible consequences that would ensue if any contact should be made. I think the court can rest assured that the complainant need not worry about any contact being made by the defendant.
Well, I'm looking at this probable cause affidavit. It's disturbing to say the least. Each act was a crime. Each act is a crime. They only indicted you once for one. But each act is a crime of what I'm reading about, these threats. And does the defendant have a criminal history at all, any at all?
He does, Your Honor, but they're from, none of them are any offenses involving violence, and the ones that he does have are like from 20 years ago.
I don't believe there's any felony history, Your Honor.
Okay. All right, these, I'm looking at one set of messages here on January 3rd.
Yeah,
Let me just, it's not a debate. I'm reading this and it's what it is. There was, these are very, you would have to agree, these are most disturbing. Disturbing. Oh, okay.
Yes, sir.
Okay. All right. If they were true.
There is a
There's
presumption of it.
voice. There's, y'all have voicemails on this, recorders voicemails? There, it says, sent 2 emails with 2 voicemails. And the first voicemail said one thing, and I mean, these were, then the officers received additional emails from the complainant with screenshots of missed calls and a text that was sent to the complainant's son, which was a picture of an insurance policy. Do you have that?
Yes, we have that.
Okay. Okay. All right. And these emails, screenshots. And Officer Avery received an email from the son of the complainant that he received a new photo of his mother via text message for the second time. I mean, this was a period of time where heck was occurring. This was very threatening and intimidating. It hasn't occurred since.
To my knowledge, no, Your Honor,
I
but
think it's because of what she came forward and had the courage to make a complaint, and that the conditions of bond that was set for freezing this action. But this is not just one isolated event. This was several things that happened.
That are alleged to have happened, Your Honor, and I would say
Either the messages, come on, y'all have text messages?
But Your Honor, the text message.
I'm sorry. Y'all have text messages?
yes, we have all of the evidence that we got from the police department.
All right. So you're saying those are contrived and made up?
No, I'm just saying there's.
You're nodding and he's saying no. Y'all need to get on the same page. Here's what we're gonna do. The condition of bond continues. We're freezing this and this situation until we can get this thing to trial. But I've done this so long, I know what happens. Passion plays in all romantic interest. There's passion in it, and it makes people, it can cause people to act sometimes in a way that's unreasonable to what they normally act like. But what we're going to do is shame on somebody. The first time, shame on me. The second time, on my watch, if I let the guard down. Right now, there's nothing bad happening that I'm aware of.
That's correct.
So we're going to continue the status quo until we can get this thing disposed of. And try to get it as fast as I can. I've tried 600 jury trials. I'm going to brag about it because I don't understand. 600, and that doesn't stop people from asking for trials here. You would think people would say, "Oh, he's going to try this case." We all know 98% get disposed of without a trial. For some reason, 98% go to trial here, and I can only try one at a time. But when you find a judge that's tried 600, let me know. Felony trials, let me know, because this doesn't happen. We're working one at a time as hard as we can. And one of the reasons we don't have additional problems while on bond is the court's bond is firm about the bonds. And he's going to have to kind of bear with this a little longer until we can get this disposed of. But nothing bad is happening according to the state. And the court feels like the bond condition on his device is and it is, in not in his case, but in almost all cases, stops issues and keeps the status quo from changing for the worse while we're waiting. And that's, I appreciate your vigorous representation of him, but this is in the best interest of all concerned. And that's my good point. What are we going to do on this?
State is ready for trial. We were ready today, Your Honor. It's just a matter of getting it on a trial docket and reaching it.
Okie dokie, friends. Well, he muted, and quite honestly, there's only a couple of minutes left before I need to depart, so this is probably the best place to leave it for today. Again, apologies that we're an hour short, but it's that time of year where I do have multiple business commitments that have to be dealt with, and this morning I need to claw back another hour to handle them, so that is the situation. But we will be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, as always. So I look forward to seeing you all then. Thank you all for joining me today. Barbara, again, thank you for your super chats. Very much appreciate it. Go have yourselves a great day. We'll look forward again to seeing you tomorrow. Take care. God bless.